Mr. Okoro. Mr. Okoro, you are trying to connect your audio. Mr. Okoro, are you with us? Because I can see you, I can see, but I'm yet to see your face. Mr. Okoro, can you hear me? Check your audio. I can see Edwin Okoro. Do you have an issue with your internet? I can actually see you. Court registrar, did you contact the counsel for the respondents?
Yes, both of them were contacted. The last day, I called them personally. I sent them the password. When the matter was adjourned today, I still called them again and told them that my lord adjourned the matter to 19, which is today.
Have you given them the new password?
Yes, my lord, I did to all of them yesterday, including Barrister Okoro here.
Yes, Barrister Okoro. Next counsel, unmute yourself.
Unmute yourself.
I can see you, but you are muted. Yes. Can you hear me now?
Yes, my lord, I can hear you.
Very well. So none of the parties is in court?
Yes, my lord.
Appearances?
My lord, with humility, I am Edwin Okoro, humble appearance for the claimants.
Any other appearance? New for the respondent. I need to let you know that because this matter, the 90 days falls into this vacation period, I had to obtain a fiat to enable me deliver the judgment during this time. So I have the fiat of the Honorable, the President of the National Industrial Court of Nigeria to deliver this judgment during this vacation period, as required by the rules of this court. So I'll go ahead now and deliver the judgment. The respondent may obtain the clean copy of same. By originating summons dated 12th of October, please mute yourself. Please mute yourself, yes. By an originating summons dated 12th of October 2021, the claimant prays the court to determine the following questions. 1, whether there are valid discriminatory grounds preventing the decision of a police service commission at the 24th plenary session meeting on the 27th and 28th of September 2017 in relation to maintaining the date of appointment as cadet officers as the date of their first appointment from inuring in favor of the claimants. 2, whether if by the above issue is resolved in favor of the claimants, the following consequential orders should not be made. A declaration that the decision of the first defendant in the 24th plenary meeting in relation to the regularization of date of first appointment of the claimants is valid and subsisting. 2, a declaration that the date of the first appointment into service of claimants as contained in the appointment letters of 10th of June 1994 for those of Cause 33, 6th of August 1996 for Cause 34, and 13th April 2000 for Cause 35, respectively, are not subject to a review by the second and third defendants. 3, an order nullifying the unlawful purported retirement from service of some of the claimants of Causes 33, 34, and 35 forced entrance by the second and third defendants contrary to their date of first appointment into service as contained in their respective appointment letters. 4, an order directing the defendants to reinstate forthwith the claimants unlawfully retired contrary to their date of first appointment into service as contained in their respective appointment letters. 5, an order directing the defendants to pay all salaries, allowances, and other entitlements to the claimants affected by the unlawful retirement upon their reinstatement. 6, an order mandating the defendants to update forthwith the service records of the claimants to reflect 25th June 1994 for cause 33, 15th August 1996 for cause 34, and 1st May 2000 for cause 35, respectively, as the date of their first appointment, in line with the decision of the first defendant in her 24th plenary meeting in relation to the regularization of the date of first appointment. And 7, an order of perpetual injunction restraining the defendants jointly and severally from unlawfully and prematurely retiring the claimants of causes 33, 34, and 35 first entrants of the police academy affected by the decision of the first defendant in her 24th plenary meeting in relation to regularization of the date of first appointment. Accompanying the originating summons, the 27th paragraph affidavit deposed to by the third claimant on behalf of himself and the other claimants is representing, wherein he averred that they are police officers and members of causes 34, 33, 34, and 35 first entrants of the police academy. They averred that the defendant from 1989 started a policy of advertising for vacancies in the establishment of assistant superintendents of police and inspectors pursuant to section 39 of the Nigerian Police Regulations. And again, in the year 1994, 96, and 2000, same advert for vacancies was also advertised. In response to that, some qualified 7 members of the rank of and file with university degrees who were interested in cadet program were directed to resign their appointment and apply for the program afresh like their civilian counterparts. They averred that the defendant may declare that applicants should resign their previous appointment thereof. Any successful candidate who is appointed into the cadet program is deemed to have resigned from over and above their civilian counterparts who joined the force with them. They stated that over the years, that is 1994, 96, and 2000, several officers and men subscribed to the cadet force entrant programs, applied and were appointed as cadet ASPs and inspectors respectively. Claimants continued that they worked very hard, rose through the ranks and received promotions from time to time from the defendant. He further averred that subsequently, some officers of the force entrants who subscribed to the cadet program received directives from the police authorities to come to force headquarters to revert to the earlier appointments that they were made to resign and abandon. Consequence of that, they made several complaints and petitions. With the consideration of several complaints and petitions, the first defendant arrived at a decision that all officers directed to resign their appointment before taking up a fresh appointment into the cadet program are to maintain the date of their appointment as cadet officers as the date of their first appointment. They stated further that instead of complying with the said decision across board, the second and third defendants reinstated some officers, but directed some of the officers to proceed on retirement. As a result of this, claimant proceeded to court. That in that suit, judgment was delivered in their favor, and the defendant recalled the retired officers and obeyed the judgment of court in respect of the date of first appointment in the suit filed by causes 18, 19, causes 18 and 19, that however, the second and third defendant refused to apply the decision of the first defendant in her plenary meeting in respect of the date of first appointment in favor of the claimant's hearing, even though they train alongside the members of cause 18, 19, and 24 entrants by insisting that there is no judgment of any court in the claimant's favor. It was the final position of the claimants that this refusal has caused a negative effect on them, and they pray the court to grant their consequential reliefs. Learned counsel on behalf of claimant filed their file address in support of the originating summons. I have reduced the most pertinent part of it into the body of the judgment. The first defendant in opposition to the originating summons filed a 10-paragraph counter affidavit deposed by one Harun Usman, a senior executive officer attached to the legal department of the Police Service Commission, and have reduced his deposition. He also filed an address by framing one issue, and that has equally been reduced into the body of the judgment. The second and third defendants in opposition to the originating summons filed a 20-paragraph counter affidavit. I have reduced the facts also, and they filed written address wherein they framed 4 issues for the determination of the court. I've captured the pertinent part into the body of the judgment. The claimant responded to both the counter affidavit of the first respondent and that of the second and third respondent by filing a further affidavit and equally filed addresses. I have reduced all those also into the body of this judgment. I will now go straight to the judgment of the court. I've considered the originating summons filed by the claimants together with the accompanying processes. I've equally read all the processes filed by the defendants in response to same. It is in my humble view that the issues, the consideration of which will meet the justice of this case are: 1, whether or not there is a cause of action against the first defendant in this case and thus a adversary party, and 2, whether or not the claimants have proven their case and thus entitled to the grant of relief sought before this court. I would like to address some issues at the outset before proceeding with the cross of this suit. First, Leonard First Defense Counsel Babatunde Dada Esquire, in his written address in support of the counter affidavit filed on the 17th November 2021 at paragraph 3.1, cited the case as, quote and unquote, Scam Consort Nigeria Limited versus Godwin S. Eond OK. It is germane for me to state that there is no case law authority with such names. What I found as revealed from my research is the case of Scam Consort Nigeria Limited and another versus UK. Citation provided. Courts in this claim have reminded counsel when citing cases to do so with precision and clarity. It is the most unprofessional for learned counsel when citing authorities they intend to rely on in the pursuit of their case, and would like the court to consider to do so with a lot of due diligence and accuracy. The case law authority cited inappropriately is not worthy of giving any credibility or value to by the court. Such is to be discountenanced by the court. It is in the light of this that I discountenance the case of Scam Consort Nigeria Limited versus Godwin S. Eond OKEY, cited by the First Defense Counsel, as there is no such case law authority in existence. It is the contention of learned claimant counsel that exhibit attached to the second and third defendant counsel affidavit, that is, exhibit NPF1 to NPF4, are computer-generated documents. The requirement of tendering same ought to be in compliance with Section 84 of the Evidence Act. That the second and third defendant failed to comply with Section 84 of the Evidence Act, I find attached to the second and third defendant's affidavit documents marked as exhibit NPF1, NPF2, NPF3, and NPF4. By the provision of the law and rules of court, the proceeding herein by its nature is an originating summons which must be accompanied with affidavit. In fact, Order 3, Rule 17 of the Civil Procedure Rules of this court, 2017, also provides that an originating summons is to be accompanied by an affidavit, copies of instruments sought to be interpreted, and a written address to which the respondent is to equally file the counter affidavit and its accompanying documents, if any. This is a genre of proceeding that is fought on affidavit evidence. In actions commenced by originating summons, as in this instance, the affidavit evidence takes the place of pleadings. The averments are on oath and are of the same evidential value as a witness statement on oath front-loaded in a suit commenced by writ of summons in which pleadings are filed. The counter affidavit serves as a statement of defense. It is to be noted that evidence by affidavit is a form of documentary evidence which is prima facie admissible. It is entitled to be given adequate weight where it is concrete, cogent, credible, and there is no conflict. See the case of NCC versus Motophone Limited and another citation captured. The law is tried that document attached to an affidavit forms part of the affidavit. I've carefully examined the exhibit in contention. We find first that they are very dark, they are unclear, with no source or signature. There is nothing on the documents to evince that they emanate from the second and third defendants. They equally have red ink markings on each of the exhibits. I wonder how the second and third defendants expect the court to ascribe any probative value to such documents. Of what use is a tainted, ambiguous, and an unsigned document? The documents must be of any value. The documents cannot be of any value to the court. No weight can be attached to such documents. I cannot equally make any head or tail of the documents. See the case of Dvision and others versus INEX citation captured, the case of Sani and another versus Akwe and others citation also captured. It is in the light of all stated that I find that the exhibit attached to the second and third defendants counter affidavit, that is exhibit NFP1 to MPF4 are of no probative value and thus discountenanced. On the contention by the second and third defendants that the claimants in causes 33, 34, and 35 lack capacity to sue because they have not shown how their personal interest is adversely affected by the decision made in the judgment in Exhibit K. The question whether the claimants have sufficient interest or not, as stated earlier, depends on the facts and circumstances of this instance suit. This is challenging the capacity of the claimants to institute this action against the defendants. And that goes to the very foundation of this suit and does affect the jurisdiction of this court. In other words, where a party has no locus standi, or put in another way, the capacity to sue, the court cannot assume jurisdiction to entertain the action at all. In the case of Olukotu and others versus Alaye Mola and others, citation captured. The case of AZ and AG of Rivers State, citation captured. The case of registered trustees of Masters versus Ministries Nigeria Incorporated versus Emenike and others, citation also captured. Where claimant or applicant has no locus standi to bring a suit, the suit becomes incompetent and the court lacks the jurisdiction to entertain it. The only order the court can make in the circumstance is that of dismissal. See the case of Achonia and another versus AZ and another, citation is also provided. In the case of Inyesom and Peterside and other, citation provided, the Apex Court held that in order to determine whether a party has locus standi, what should be considered is the pleadings, which in this case, the affidavit in support of the originating summons, that will be considered by the court, and the claimant must show sufficient interest in the subject matter of the suit. In essence, where the claimants disclose sufficient interest in the subject matter of the suit, they are entitled to sue. In other words, the claimant must be able to show that their personal interest will be affected or adversely affected by the subject matter of the suit. The most germane question to answer now is, has the claimants in this case disclosed sufficient interest in the subject matter of this action, which is whether or not the policy of the first defendant on the first date of appointment of cadet ASPs should be implemented in their favor, as they did for their colleagues of causes 18, 19, and 20. The claimants, without any shred of doubt, as evinced by the affidavit in support of the originating summons, have a legal right respecting the policy of the first defendant to be partakers of that policy. The claimants, being employees of the first defendant, by their affidavit are entitled to benefit from any policy of the first defendant as it relates to their employment, including the regulation of first date of appointment. Obviously, what the claimants are seeking for in this action is for the declaration of their rights to the said policy of the first defendant and the implementation of same in their favor. I find from all the facts disclosed in the affidavit that the claimants have sufficient interest in the subject matter of this action, which is to answer the question on the implementation of the policy of the first defendant. Consequently, I hold that the claimants have locus standi to institute this action. Now to the first issue framed by the court. The grounds of the first defendant is that the claimants failed to fulfill the condition precedent to the filing of the suit, and that, according to it, has robbed this court of its jurisdiction. According to the first defendant, the claimants ought to have issued a month pre-action notice to the first defendant before proceeding to this court, failing which the suit is not competent. It is the response of the claimants that averments in affidavit evidence as in pleadings must be specifically denied by the opposing party, failing which it is to be deemed admitted and uncontroverted. The failure of the first defendant to controvert paragraph 27 of the affidavit in support of the originating summons in their counter affidavit means they have admitted the fact that claimants issued a pre-action notice on the first defendant. Then counsel for the claimants argued further that the address of counsel to the first defendant on this issue cannot take the place of evidence and should thus be discountenanced. A condition precedent has been defined by the Supreme Court in the case of Atolagbe and Awuni, citation captured. Thus, and I quote, a condition precedent is one which delays the vesting of a right until the happening of an action or of an event, unquote. See also the case of Adams and others versus AG Lagos State and another citation provided. The case of Polaris Bank versus Magic Support Nigeria Limited, citation equally captured. This condition makes the existence of a right dependent on the happening of an event. The right of the claimants to ventilate their grievances before this court by instituting this present suit is conditional upon first issuance and service of pre-action notice on the first defendant pursuant to section 20, subsection 3 of the Police Service Commission Establishment Act 2001. It is also a requirement of the rules of this court that a copy of a pre-action notice issued by a claimant to an opposing party, where required, should accompany the originating processes. See Order 3, Rule 23, Sub-Rule 1 of the Civil Procedure Rules of this court, 2017. I find on record, specifically at page 41 of the case file, a pre-action notice dated 11th of August 2021, addressed to the claimant of the, addressed to the chairman of the first defendant, marked as Exhibit N, accompanying the originating summons filed in this case, and facts relating to same, was equally averred at paragraph 27 of the claimant's affidavit in support of the originating summons. As rightly noted, the first defendant failed or refused to controvert the claimant's averment that they were served the pre-action notice on the averment that the first defendant was served with a pre-action notice by the claimants. The import of this is that the first defendant is deemed to have admitted the fact that the claimant did in fact issue and serve a pre-action notice on the first defendant via Exhibit M addressed to its chairman. See the case of Inakoju and others versus Adeleke and others, citation captured. The case of Ogoje 4 and Ogoje 4, citation captured. The case of Ajomale and Yaduat, number 2, citation also provided. The court in the case of Inoye versus Anyiche, citation provided, reasoned that an objection on pre-action notice should be raised preferably soon after the defendant is seized or served with a writ of summons. The court held a failure to serve a pre-action notice where it is required is only an irregularity which renders the action incompetent but can be waived. That where a party fails to make it an issue, either by motion or plea, same in the statement of defense or counter affidavit as in this instance, it has waived his right. Failure of the first defendant to controvert in its counter affidavit of non-service or pre-action notice amounts to a waiver of same. It is in consequence of all said herein that I find that the claimant satisfied the condition precedent to the filing of this suit. Accordingly, I hold that the claimant's suit is competent before this court. Then a counsel for the first defendant equally contended that there is no cause of action against the first defendant in this case. To the claimants, on the other hand, there is a cause of action against the first defendant in that it is at the plenary of the first defendant that the main issue before the court arose upon which the first defendant pronounced and issued a circular. By the case law authority of Adekwa and Federal Housing Authority, The notorious case on this subject, citation captured, the case of Governor of Oyo State and others, Uzajunwa and others. A cause of action is a combination of facts which gives rise to the right of action or relief. By the case of AG of Federation and AG of Abia, citation captured, it is sufficient for a court to hold that there is a reasonable cause of action once the statement of claim or statement of facts herein in a case discloses some cause of action or some questions fit to be decided by a court, notwithstanding that the case is weak or not likely to succeed. The fact that the cause of action is weak or unlikely to succeed is no ground to strike it out. It is well settled that the court must look at the claim of the claimant to determine whether it has jurisdiction or not. See the case of Federal Government of Nigeria versus Oshiomhole, citation captured, the case of Attorney General of the Federation, and Guardian newspaper limited citation provided. Paragraphs 4, 5, 6, 8, 13, 14, 15, 17, 18, and 22 of the claimant's affidavit in support of the originating summons are all facts and combination of facts that give the claimants the right of action against the first defendant. The claimant's affidavit reveals that the first defendant is the body that employs, promotes, and disciplines the claimants, that it made the policy at the plenary meeting of the 27th and 28th of September 2017 in relation to maintaining the date of appointment of the cadet officers as the date of their first appointment, that the first defendant directed the second defendant to implement the decision which was implemented in respect of cadet officers of courses 18, 19, and 20, but failed to implement the policy in their favor, the reason for this suit. Apparently, the cause of this suit revolves around the first defendant being their employer, who made a policy respecting their colleagues, but failed to enforce it in their favor. It is in consequence of all those facts on record that I find that the claimants have shown that they have a cause of complaint against the first defendant in this case, which demands the pronouncement upon by the court. I so find and hold. Next is issue 2, framed above. Claimants as espoused in the main are seeking for the interpretation as to whether there are valid discriminatory grounds preventing the decision of the Police Service Commission at its 24th plenary meeting of 27th and 28th of September 2017 in relation to maintaining the date of appointment as cadet officers as the date of their first appointment from inuring in their favor. It is not in doubt that the claimants in this instance suit are in the employment of the defendants, and they claim that they are being discriminated from the decision made by the first defendant at his 24th plenary meeting, which infringes on their fundamental right. This court, by section 254C, subsection 1, paragraph D of the 1999 Constitution as altered, is empowered to adjudicate on matters relating to or connected with any dispute over the interpretation and application of the provision of Chapter 4 of the Constitution as it relates to any employment, labor, industrial relations, trade unionism, employers association, or any other matter which the court has jurisdiction to hear and determine, unquote. The cause of the claimant's case is that the refusal of the second and third defendants to enforce or apply the decision of the first defendant respecting their first date of appointment in sync with the policy of the first defendant at its plenary of the 27th and 28th of September 2017 is discriminatory against them and in breach of section 42 of the Constitution as amended, hereafter called the Constitution. In other words, claimants are seeking the interpretation of section 42 of the Constitution as it affects their rights to retain their job on the implementation of the policy of the first defendant. The question that the claimants pose for the determination of this court is whether the action of the defendants is not discriminatory as stated earlier. It is the answer to the question posed above that will determine whether the declarations will be made or not. See the case of Oli versus Tunji, citation captured, the case of Atago and Nwuche, citation equally captured. I find that the question posed by the claimants and the declaration sought in the instance suit do not give room for dispute of facts or contention. This is simply because these declarations do not have a life of their own. Whether or not they will be granted depend on the answers given to the question formulated, which are purely based on the interpretation given to the policy of the first defendant and the previous judgment of this court. I'm therefore of the firm view that facts in this case are not hostile nor contentious. The suit is properly instituted by way of originating summons, I so find and hold. The claimant in this instance suit brought this action in a representative capacity, and it is tried that persons may bring an action in representative capacity in order to seek redress for a wrong done to a group of people, where a group of persons have common interests and common grievance. A representative suit is in order if the relief sought is in its nature beneficial to all whom the claimant proposed to represent. Once it is not challenged that they have common interest, representative action can be brought. See the Supreme Court case of Dover Hotel PLC and Itoy and other citation captured. The case of Togwa, Ogamioba and others versus Chief D, Ogene and other citation also captured. Claimant in this instance suit has stated supra seeking redress against discrimination from the decision made in the 24th plenary meeting of the first defendant against members of their cause 33, 34, and 35. The relief sought, if granted, is beneficial to all the claimants in this suit and those they represent. Claimants in the present suit are merely seeking for the interpretation of a policy of the first defendant, as well as the earlier suit as it affects their legal right in the police force. The said policy of the first defendant at its 24th plenary meeting sought to be interpreted in this present suit is the same with the one referred to in the previous judgment of this court represented in this suit as Exhibit K. It is clear from the facts before the court that the first defendant, who undoubtedly is the employer of the claimants by sections 153, subsection 1, paragraph M, subsection 2, and section 215, subsection 1B of the Constitution as amended, is empowered to appoint, promote, and discipline police officers. The first defendant admitted that the claimant's appointment as cadet ASPs was a fresh one and relied on the minutes of the 24th plenary held on the 27th and 28th September 2017, wherein its decision in the case of an appeal for regularization respecting aggrieved officers of course 18 and 19 stated thus, I quote, that in line with previous decisions taken on similar matters, the officers with similar situation covered by signal number CE 2710/FS/3/205 dated 1st of June 1989, who were directed to resign their appointment as NCOs before taking up fresh appointment as cadet ASPs, are to maintain the date of their appointment as cadet ASPs as the date of their first appointment, unquote. The circular went on to urge the IG to implement the decision conveyed to the officers and inform the commission accordingly. Also, the letter dated 25th of October 2017, which was addressed to the second defendant, clearly reiterates its decision in its 24th plenary meeting. Again, the first defendant in its most recent letter dated 22nd of June 2020 emphasized its earlier decisions highlighted supra, and in addition stated unequivocally that, I quote, all officers with similar situation covered by signal number CE 2710/PS/3/2205 dated 1st of June 1989, who were directed to resign their appointment as NCOs before taking up fresh appointment as cadet ASPs, are to maintain the date of the appointment as cadet ASPs as the date of their first appointment, unquote. I find from the content and purport of the letter dated 22nd of June 2020 that the claimants who have similar situations with those of cause 18 and 19 and captured in signal number CE 27010P/PS/3/205 dated 1st June 1989, who were also directed to resign their appointment as NCOs before taking up appointment as cadet ASPs, are equally to maintain their first date of appointment as ASPs as their date of appointment. The intent and tenor of the signal and the two letters captured herein above are unambiguous and requires no external aid to interpret. The letters and signals speak for themselves. They are all speaking the same language and conveying the same message, which is that all officers who were given the opportunity to attend cadet course and in fact attended cadet ASP course after resignation of the appointment as NCOs first from the force are to maintain the date of the appointment as cadet ASPs. The import of which is that the above policy is applicable to all concerned officers who fall into this category, and none should be excluded from taking benefit of this policy. Now, Section 42 of the Constitution provides, and I quote, "A citizen of Nigeria of a particular community, ethnic group, place of origin, sex, religion, or political opinion shall not, by reason only that he is such a person, A, be subjected either expressly by or in the practical application of any law in force in Nigeria or any executive or administrative action of the government to disabilities or restrictions to which citizens of Nigeria of other communities, ethnic groups, place of origin, sex, religions, or political opinions are not made subject, or B, be accorded either expressly by or in the practical application of any law in force in Nigeria or any such executive or administrative action, any privilege or advantage that is not accorded to citizens of Nigeria of other communities, if ethnic groups, places of origin, sex, religious or political opinions." Subsection 2, no groups, no citizens of Nigeria shall be subjected to any disability or deprivation merely by reason of the circumstances of his birth, unquote. The law is that a liberal approach must be adopted when interpreting the Constitution of Nigeria, and especially the fundamental right provisions. Section 42 of the Constitution guarantees to every citizen of Nigeria freedom from discrimination on the basis of belonging to a particular community, ethnic group, place of origin, sex, religion, or political opinion. Particularly, Section 42, subsection 1B forbids discrimination on the basis of practical application of any law in force in Nigeria or any executive or administrative action or any privilege or advantage as in the present case. In answering question 1 posed by the claimants in the originating summons, the provision of the Constitution is clear. Thus, by Section 42 of the Constitution of the Constitution, the defendants cannot exclude the claimants from the applicability of the first defendant policy on the first date of appointment of cadet ASP officers. It is in my respectful view that claimants should also be classified as previous to the decision made by the first defendant in its 24th plenary meeting, and also to the decision made by this court in Exhibit K in respect of Cost 20 entrance. The judgment in Exhibit K and the decision made in 24th plenary meeting should benefit not only the claimants in this suit, but also all those who come within the legal ambit of previous to the parties in Exhibit K, as the sister case has complied with by the first and second defendants, read Exhibit A. See the case of General Telephones and Electronics versus AMCON, citation provided. Consequently, I find and hold that there are no valid ground preventing the decision of first defendant at its 24th plenary meeting in respect of maintaining the date of appointment as cadet officers as the date of their first appointment for manuring in favor of the claimants herein. The aphorism that would best portray or describe the position of the court as it affects the claimants herein is that what is good for the goose is equally good for the gander. Accordingly, I resolve question 1 in favor of the claimants. Now to release 1 and 2 taken together, the claimants are seeking for the court's declaration that the decision of the first defendant in its 24th plenary meeting in relation to regularization of the date of first appointment of the claimant is valid and subsisting. A pertinent question to answer here is, what is the effect of resignation and the subsequent letter of appointment offered to the claimants by the defendants? It is tried that the effect of resignation signifies the end of employment relationship. The defendants directed the claimants and those they represent to resign their earlier appointment by taking up a fresh appointment as cadet ASPs or inspectors. They did and proceeded to the police academy in Kano, and the defendants on the 10th of June 1994, 6th of August 1996, and 13th of April 2000, issued the claimants new letters of appointment as Cadet Assistant Superintendent of Police with effect from the date they report for training. Paragraph 2 of the letters specifically requested them, quote, to report to training at Police Academy Kano Staff College for 18 months training, which commences on 1st of May 2000, unquote. Therefore, the content and tenor of the letter written by the defendants to the claimants invariably and logically means that the claimants were offered a fresh appointment and the defendants cannot by any stretch of imagination or guise renege or resile from it as the law is settled. The parties are bound by their contract of agreement. See signals DTO 261340/06/89 and DTO 221535/05/89. The law is on a firm footing that in the construction of documents, the cardinal principle is that parties are presumed to intend what they have in fact said or written down. Accordingly, the words employed by them will be so construed and should be given the ordinary and plain meaning. It is in the light of this and given the clear content of the signals and letters supra that I find that the defendants are bound by the contract, either the letters of appointment dated 10th of June 1994, 6th of August 1996, and that of 24th of April 2000 issued to the claimants herein. It is apparent from the letters dated 25th of October 2017 and the subsequent one dated 22nd of June 2020 that the first defendant in its 24th plenary session effectively settled the issue when it decided that the claimant first date of appointment should be when they were appointed as cadet ASPs. It is the law that when a document is clear and unambiguous, as I've stated, alluded to supra, the operative words should be given their ordinary and grammatical meaning. See the cases of Aharawa versus and another citation captured, the case of NNPC versus Aminu, citation also captured. From the above stated, it is clear that the regularization of date of first appointment of the claimants are in Bain's bid as C, D, as in Bain's bid as C, D, and E, are the dates, that is the 10th of June 1994, 6th of August 1996, 13th April 2000, these dates respecting members of courses 33, 34, and 35 is valid and subsisting and cannot be reviewed by the second and third defendants. Court registrar, mute yourself. Mute yourself, court registrar. Therefore, claimant release 1 and 2 does succeed. Claimant by their release 3, 4, and 5, taken together, are praying for the nullification of a retirement from service of some of the claimants of causes 33, 34, and 35 by the second and third defendants, in order for their reinstatement and payment of salaries. The defendants in reaction stated that the claimants retired when they reached the 35 years mandatory retirement date. That the second and third defendants on that basis retired them in accordance with the public service rules and were all paid their retirement benefits. That they cannot now turn back and challenge their retirement or seek reinstatement. Now this court in the earlier 2 sister cases, one of which is Exhibit K, did not say that the claimant should serve the police forever. Learned Defense Counsel stated that the claimants, having retired, cannot be called back to the force. It is the law as stated earlier that he who asserts must prove, because the burden of proof lies on the one who would fail where no proof is given, and he must discharge such proof on the balance of probability. See sections 131 to 133 of the Evidence Act. On the case of Muhammad versus Wamako and other citation captured, the case of Orion Z versus AG River State and other citation captured, the case of Lutin Investment, the case of NNPC versus Lutin Investment citation also captured. I've earlier held that for the purpose of calculating the dates of first appointment of claimant, it should be the 25th of June 1994, 15th of August 1996, and 1st of May 2000. It is however glaring on record that some members of the claimants by letters dated 6th of February 2019, that is Exhibit H, and 4th of April 2021, Exhibit J, the first defendant approved the retirement of the first and fourth claimants. Now, the germane question that I need to answer here is, Was the retirement of some of the claimants unlawful? In the case of NSRMEA versus Isan, citation captured. The term retirement means bringing the service of an employee to an end. Retirement could be mandatory, compulsory, or voluntary. Mandatory retirement is when an employee in the public service or civil service or any government agency has attained the requisite age or years of service. Compulsory retirement connotes when an employee's employment is brought to an end prematurely by his employer as a measure of punishment. Voluntary retirement, on the other hand, is a retirement done willingly by the employee, even before the time of his the date of his retirement. In effect, the actions of the claimants to me and by their notification of retirement, which is not before the court, but deducible from their letters of retirement, which made copious reference to it, did not show in any way that they were coerced into tendering their letters of retirement. This means that they willingly retired from the service of the police. It is a settled position of the law in labor jurisprudence that parties to a contract may choose to determine their relationship by giving notice as prescribed by its terms of contract. It is tried that every employee has a right to resign or retire from his appointment whenever he or she so desires, and this takes effect when same is communicated or received by the employer, even when the employer does not expressly accept it. From the fact on record and circumstances of this case, the claimants who were retired by the first defendant unilaterally brought to an end their various employment relationship with the defendants by writing a letter notifying the defendants, and same was approved. There cannot be approval if there is no application or notification seeking an approval. Having notified the defendants of their mandatory retirement, the court cannot nullify such, save where it is found that their retirement was unlawful. I find no document on record to evince that the claimants were forcefully retired by the defendants, which would have amounted to an unlawful retirement. The law is notorious that courts should not decide a case on mere conjecture or speculation. Courts are courts of facts and law, and there should be no room for speculation. See the case of Amasa and others versus Chairman National Population Commission and others. The case of Orissa and the state citation captured. Therefore, a court can only decide a case on facts and evidence established before it. The claimants who have been retired fail to evince before the court credible and cogent facts to prove that their retirement was forceful or they were coerced into retiring and thus unlawful. By the case of Shacks and Chief of Air Staff and another citation captured, a person who has voluntarily resigned or retired from an employment cannot turn around to claim that he's still in the service after his resignation has been approved. I am of a firm view that the claimants deliberately refused to exhibit the letters of notification of their retirement referenced by the first defendant in the approval for retirement letter, just so that the court would not see that they voluntarily notified the defendant of their retirement before same was approved. In view of the peculiar facts of this case and the fact that the claimants have been paid their terminal benefits, they cannot turn around and complain that their employment subsists. See the case of Alasan versus A.B. Zaria and other citation captured. In the case of Ekiagwa and Nigeria Army citation captured, it was held that where an employee accepts salary or payment after employment is brought to an end, he cannot be heard to complain later that his contract of employment was not properly determined. Acceptance of payment by the employee has rendered the determination mutual. The Supreme Court in the case of Fasade and Babalola citation captured held that a person on who a right or benefit is conferred can waive same either completely or partially, since the rights are solely for his benefit. Supreme Court stressed further that where the right is waived by that party, cannot be heard thereafter to complain. It is obvious that the members of the claimants who notify the first defendant of their retirement, upon which the first defendant in turn acted and approved same, have waived their rights to enforce the first defendant policy of the 24th plenary on the date of first appointment of ASP cadet officer. They have thus failed to show to the court that their retirement is unlawful for it to have qualified for notification. It is in consequence that I find that the retirement of some members of the claimant by the defendant was lawful, having held that the claimant's reliefs 3 and 4 fail, or relief 5, which is a consequential relief to reliefs 3 and 4, is bound to also fail. Accordingly, I hold that claimants relief 3, 4, and 5 fail. Relief C of the claimant is for an order mandating the defendants to update forthwith the record of service of the claimants to reflect their first date of appointment as cadet ASPs on the 25th of June 1994 for cause 33, 15th August 1996 for cause 34, and 1st of May 2000 for cause 35, in line with the decision of the first defendant in its plenary meeting in relation to the regularization of the date of first appointment. Worthy of note, on the record of this court are 2 letters attached to the first defendant counter affidavit. They are letters dated 29th of July and 7th of October 2021, respectively. The letter dated 29 July 2021 made reference to the 2 earlier decisions of this court in the same subject matter as in this present, and at paragraph 2, reference the letter dated 27th April 2021, wherein it requested the second defendant to implement the 2 court decisions, and whereof the second defendant equally referred to his letter dated 30th April 2021, confirming compliance with the 2 judgments of this court. The first defendant at paragraph 5 of the letter requested for a joint meeting of the Commission and the Nigerian Police Force to take a holistic view of the problem as it relates to other similar issues before the Commission. The letter dated 7th of October 2021 is from the second defendant nominating 4 officers as his representative to the joint committee. These 2 letters, which are Exhibit A herein, are clear indication of a clear intention of the defendants, particularly the first defendant, to resolve the issue of the claimant's first date of appointment. So it's therefore in view of the clear purport of claimant's letters of appointment as cadet ASPs, as well as the unambiguous purport and content of Exhibit A, that I mandate the first defendant, who is the employer of the claimants who are still in the police force, to update forthwith the record of service of the claimants still in employment to reflect their first date of appointment as 25th of June 1994, 15th of August 1996, and 1st of May 2000 for cause entrance 33, 34, and 35, I so order. The claimants are finally praying for the court for perpetual injunction, restraining the defendants jointly and severally from unlawful and prematurely retiring the members of cause 33, 34, and 35 false entrance of the police academy affected by the decision of the first defendant at its 24th plenary. I'll consider this relief in 2 tranches. First, for those officers who voluntarily retired as have held that their retirement is mutual and cannot be held to be unlawful, the court cannot thus pronounce any restraining order against the defendants in that regard. However, for other members of the claimants cause 33, 34, and 35 entrants who are still in the service of the first defendant, have held supra that their date of first appointment are 25th June 94, 15th August 96, and 1st of May 2000 for cause 33, 34, and 35 of the police academy. The claimants have proven to the court that they have a legal right to preserve in this case. The law by case law authorities is long settled that the grant of relief or perpetual injunction is a constitutional order which should naturally flow from the declaratory order sought and granted by the court. The essence of granting a perpetual injunction on a final determination of rights of parties is to prevent permanently the infringement of those rights and to obviate the necessity of bringing multiplicity of suits in respect of every repeated infringement. See the case of Goldmark, Nigeria Limited and others versus Ibafo Company Limited and others, citation captured. The case of LSPDC versus Banire, citation captured. The case of Afrotech versus MIA, citation captured. It is in the light of all stated herein in this judgment that I restrain the defendants and their privies from retiring the claimants except when they reach the mandatory year as per their first date of appointment. I so order. Flowing from the foregoing, it is apparent that the claimant's question posed is resolved in their favor, and for the avoidance of doubt, I declare an order as follows. 1, that the decision of the first defendant in its 24th plenary meeting in relation to regularization of date of first appointment of the claimants and all members of causes 33, 34, 35 was entrant of the police academy and all those that they represent is valid and subsisting. 2, that the date of first appointment into service of the claimants and all members of causes 33, 34, and 35 was entrant of the police academy is as contained in their various letters of appointment as the 10th of June 94, 6th of August 96, and 1st of May 2000 are not subject to a review by the second and the third defendants. 3, that the retirement of some of the claimants cannot be nullified in view of the reasons profiled in this judgment. 4, that the claimants release 4 and 5 fail. 5, that the defendants are to forthwith update the service records of the claimants who are still in employment to reflect their first date of appointment. 6, that the defendants are restrained from retiring the claimants and other members of course 33, 34, and 35 still in service prematurely. 7, no award as cost. Judgment is accordingly entered. Copies of the judgment will be made available to parties in this case.
My Lord, we are very, very grateful for the erudite judgment. Thank you, my Lord.
Very well. Call the next case.
Case number NICN/ABJ/392/2020 between Nigeria Union of Public Service Reporters Secretariat, Data Processing and Allied Workers, and Jacob, Laura Makama, and another.